How to handle disclaimer office actions for trademarks. Imagine you're in the middle of the trademark registration process and suddenly receive a letter from the United States Patent and Trademark Office. This letter is called an office action, and it can seem confusing at first. But don't worry, understanding how to handle disclaimer office actions is easier than you think. A disclaimer office action happens when the USPTO asks you to give up rights to a part of your trademark. Usually, this is because that part is generic, descriptive, or a common term that others also need to use. For example, if your mark includes the word bakery, the office might want you to disclaim that word so other businesses can use it freely. The main idea is that you claim rights only to the whole mark, not to the part you are disclaiming. When you get a disclaimer office action, the first step is to carefully read the letter. The USPTO will tell you exactly which part of your mark needs a disclaimer and why. It might say that the element is too generic or descriptive. Once you understand what they want, you need to prepare a disclaimer statement. This statement must match the exact wording or design element the USPTO identified. It should clearly say that you do not claim exclusive rights to that part of the mark. Next, you need to respond within the deadline. Usually, you have 6 months from the date of the office action to reply. If it is a non-final office action, you can submit your response with the disclaimer included. If it is a final office action, you will need to file a request for reconsideration and include the disclaimer. You can do this online through the USPTO's Trademark electronic application system. When submitting your response, answer yes to the question about adding a disclaimer and type the exact words in the space provided. Do not add extra language or anything beyond what the USPTO asks for. This helps ensure your response is clear and complete. Failing to provide the disclaimer can cause your trademark application to be refused. The USPTO might reject the entire mark if the disclaimer is missing for an unregistrable part. Sometimes, you may choose to voluntarily disclaim certain parts of your mark when you first file your application. This can help avoid delays later. If you realize you made a mistake and submitted a disclaimer that is not needed, you can withdraw it through the proper USPTO procedures. Just be sure to follow their steps carefully. Handling a disclaimer office action is about acting quickly and accurately. Make sure you understand what the USPTO wants, prepare a precise disclaimer statement, and respond on time. This way, you can keep your application moving forward and protect your rights in the mark. Remember, the disclaimer will appear on your registration certificate but does not have to be used on packaging or advertising. The goal is to protect the distinctive parts of your mark while allowing others to use common terms freely.